Thank you very much. So it's for me to be the last speaker, and time is already over. And I promise to try to be as brief as possible. I actually was asked to basically comment on everybody, but I'm not supposed to make a summary of today's panels. What I would like to highlight right at the beginning is somehow my own way of thinking about the topic. And I really think that standardization should be the starting point. And the core policy question is, how much exclusivity do we actually need when it comes to standard essential patents? Because what we see in Huawei is actually that the court develops a rather regulatory approach to limiting exclusivity by denying, under certain conditions, denying injunctive relief. And this, of course, also brings us to look at the US situation, where the same goal is basically achieved within patent law. Patent law was mentioned today at the very beginning against the backdrop of the enforcement directive, and we should also mention that this directive has a principle of proportionality. The court cited the directive, but did not take advantage of this particular formula, because this would have been a wonderful basis for maybe learning from US experience and maybe to solve the problem within the remedies available under patent law. I admit that this may take much longer, because we might have a national law that does not easily allow us to interpret national law in the light of the court's interpretation of that directive, and therefore maybe competition law was the direct way to go, and of course also the referral from the German court very much focused on competition law. But in general, I want to highlight this because I consider this being the core issue: how much exclusivity do we actually need, or should we have? How much exclusivity should we have when it comes to standard essential patents? I would like to focus then on three particular topics. The first one was again alluded to by Miguel Rato, namely the scope of the application of the Huawei decision, and all my three remarks concentrate on follow-on issues of Huawei. Does it really only apply to cases of vertically integrated firms? And does it really incorporate a pure theory of leveraging of market power to a downstream product market? Indeed, the decision reads like this, but I think we can't handle it like this. Why is this so? Against the backdrop of more recent developments in Germany, I would just like to mention the very first case that was decided after Huawei by the regional court in Düsseldorf in Siswell versus Haier, a Chinese company. The remarkable aspect about the Siswell case at the very beginning is that Siswell is a patent assertion entity. It's not a vertically integrated firm. The decision is not available. It dates of the 3rd November of 2015. But the court granted an injunction, however, by applying Huawei. So obviously the court did not consider it an argument against applying Huawei, that Siswell is a patent assertion entity. Why do I think that this is enormously important? We see more and more patent assertion entities like Siswell, which is not a business model I would condemn. We need such entities for various reasons. But of course, they may also pose certain problems regarding also competition law. Why may this be a problem? In practice, we can see patent assertion entities who approach implementers by simply arguing, I have a portfolio of maybe 100 standard essential patents, and you implement the standard, and therefore you have to pay a certain amount of money, or a certain percentage of the price of the end product, period. Without telling the implementer what the patents actually are, not informing the implementer why those patents were used. So exactly the requirements that we read in the Huawei decisions are not fulfilled in such cases. And of course, for the implementer, it's completely intransparent. It might be that behind the wheel of the patent assertion entity, there is a competitor. But how should the implementer know? How should the implementer know? So whether, even if you then extend the Huawei decision in the sense, well, if this is a circumvention by a competing company that actually sells the patents to a patent assertion entity, but basically the strategy is to exclude a company by charging very high royalty rates, so we are also applied here. But how do we know? And especially the other party doesn't know. So here we have a big issue. Anyhow, I believe, and I don't know how many people here in the room will join me in this, but the problem is not the exclusion, it's the charging of high royalty rates, and the problem is if we don't control the prices, then we harm the process of standardization, which I would consider a process of innovation by itself. That's also what we see in the Commission's decision in Rambus. That is the core issue, and it applies to both sets of cases. Now I would like to come to Peter Dochtermann, and I have to react immediately to one of his remarks. The ex-nunc application. I'm a little bit surprised by this conclusion. Yes, there was the Orange Book decision, but Orange Book was not on a frank commitment. And it's very much debated whether Orange Book can be considered a precedent for those cases where the patent owners entered into a frank commitment. So whether this decision can create justified expectations about how courts in Germany would decide in the future is highly questionable. It's very highly questionable. I know people from the court that took part in the decision who are actually arguing we have never decided on a frank case, and the question was completely open under German law. So that is a first very important remark. The second one, it's about application of European competition law, which is directly applicable. How should the court in Düsseldorf decide that referred the case? On the assumption that the European competition law is relevant. And then you get back the case, and then you argue, well, it's an old case and we will not apply it. There is no ex-tunc application. So I don't really see this. I would like to hint at another point, which is much more important. There was the question to... Okay. I would like to raise another very important feature of the German development. The question was asked whether German courts are now more pro-patent owners or against patent owners. We can see very different trends. There's a new decision by the higher regional court in Düsseldorf on the Siswell case. In Siswell, the first instance court, the regional court, actually decided that there was an offer by the patent holder and that the implementer had not reacted in time, and hence the injunction was granted. In addition, the court decided to declare the decision provisionally enforceable, and also with regard to the injunction. The case went to appeal to the higher regional court, and the higher regional court suspended the latter decision, the latter part, by simply arguing that the first instance court had not entered into any assessment whether the offer by the patent holder was indeed FRAND compliant. And since there was no indication whatsoever whether this is FRAND compliant or not, this part of the judgment cannot be enforced. So in this regard, we see a clear difference between now the higher regional court in Düsseldorf, and it seems the Mannheim courts. Peter sent me also a decision from the Mannheim court with somehow the question how I see the two cases. I have to say both positions seem to me maybe partially wrong, partially right, and I feel myself torn between the two. Why is this so? I very much sympathize by the Mannheim argument that maybe the decision was designed to create a framework for negotiation, and it should be for the parties to decide what is friend and what is not. That is the very idea behind it. However, if you don't look at what the offer actually includes, the whole burden will be on the implementer, because at the very end, the implementer has the risk of providing appropriate security and might finally fail on this. So at one point, it seems courts need to decide whether the payment is appropriate or not. And I very much sympathize with what Peter said before, that maybe we simply have to look more closely at what was put on the table, and whether this actually provides enough substance for the implementer to intervene on this part. And maybe that's my last consideration, my very last consideration. This may develop over time. We have this discussion, what should be the royalty base and so on. But this needs to be decided by courts. We need to decide this question against the background of national jurisdictions, against the background of the applicable law. And the more experience we gather in this regard, and most importantly, maybe in a framework of 28 different member states, so that we can request more from the patentee's side or the patent owner's side with regard to the substantiation of what is friend and not, while the case law develops with regard to what friend actually means. And thereby, this could provide a system that may evolve over time. Right.
Thank you very much, and sorry for cutting you off, but I want to leave at least some time for the audience to put questions to individual panelists or to the panel as such.